Welcome to the final lesson of Module 4, Compliance, Risk, and Legal Operations. You've protected your IP and signed the right contracts. Now comes the ongoing work of staying legally sound. Compliance is not bureaucracy. It's the foundation your business stands on. Let's finish strong. Creative businesses operate inside a layered legal environment. 3 layers apply at the same time. The first layer, EU directives. These set the common framework across all member states. The second layer, national law. Each country implements that EU framework in its own way, so the details differ from Portugal to Estonia to Bulgaria. The third layer, sector-specific rules. The particular rules for your field and the platforms you work on. Here's the key idea. The EU sets the framework, each country implements its own version, and your sector adds its own layer on top. You don't manage these one at a time, they apply together. And because regulations change, subscribe to updates from your national IP office and tax authority. One change you miss can cause months of disruption. Within those layers, 4 compliance areas matter most for creatives. The first is IP law, protecting your own work and respecting the rights of others. The second is taxation, your income tax, VAT, and social contributions. The third is business licenses, any sector permits, or professional registrations your field requires. And the fourth is sector-specific rules, things like digital content standards, cultural heritage protections, and advertising rules. As with the layers, all 4 apply at the same time. Compliance means managing them together, not one at a time, and not only when a problem appears. For many creative entrepreneurs, tax and registration feel like the most daunting part of the whole business. So here's the reframe. The goal is not to master every detail yourself. It's to know what obligations exist and when to bring in help. Know what applies to you: business registration, VAT, income tax, and social security. Learn the deadlines before they arrive, not after. Keep good records. Most EU countries require you to keep financial records for 5 to 10 years. And know when to call a professional. A good accountant genuinely pays for themselves, especially once you have cross-border income, grants, or royalties. Your exercise here is a compliance calendar. Build a 12-month calendar of every filing date, VAT return, and license renewal, and make it visible on your wall or in your phone. Now, data protection, GDPR. And this one is simple. If your business collects any personal data, it applies to you. Client emails, website visitors, newsletter subscribers, social followers, collecting any of it brings you under GDPR. Across the EU, this is non-negotiable. So, the essentials. You need a privacy policy stating what data you collect and why, and cookie consent on any site that uses tracking. You need consent records. You must be able to prove you have lawful consent for email marketing. And you must know the 72-hour rule. A data breach has to be reported to the authorities within 72 hours. The most common violations are easy to avoid. Pre-ticked consent boxes, buying email lists, and storing client data forever with no retention policy. A free compliance check from your national data authority will catch most issues. Under GDPR, every use of data needs a lawful basis. Two matter most to creatives. The first is consent. You use it when the person must actively agree for newsletters, for marketing communications, and for non-essential cookies. That consent must be freely given, and you must be able to prove it. The second is legitimate interests. You use it for things a client reasonably expects communicating with them, invoicing them, and delivering the service they hired you for. There, you don't need a separate opt-in. The key skill is choosing the right basis for each purpose. Match the basis to the purpose, and your data use is lawful. Beyond general law, your specific sector has its own rules. Ignoring them is a frequent and costly mistake. If you're a digital content creator, watch platform terms of service, copyright content ID systems, and the EU Digital Services Act, all of which affect your reach and visibility. If you work in cultural or heritage fields, watch reproduction rights and national export restrictions on protected works. If you do advertising or sponsored content, EU consumer rules require clear labeling of every paid partnership. And accessibility now matters to everyone. The European Accessibility Act from 2025 requires digital products including websites and apps to meet accessibility standards. One more thing. If you sell or license internationally, remember that tax, platform rules, and IP protection differ significantly outside the EU. Check before you expand. Even with great contracts and compliance, disputes happen. The skill is knowing how to handle them and escalating only as far as you must. Step 1. Direct negotiation. Most disputes resolve with a single, clear, professional conversation. Start here always. Step 2. Mediation. A neutral third party helps both sides reach agreement. It's far faster and cheaper than court. Step 3. Small claims court. For lower value disputes where thresholds vary by country and you often don't need a lawyer. Step 4. Litigation. This is the last resort, costly and slow, but sometimes necessary for a serious breach or infringement. Notice that cost and formality rise with every step. So start at the bottom and climb only as far as the dispute genuinely forces you to. Finally, build your legal support network before you need it, because you don't need a lawyer on retainer. You need the right contacts, ready in advance. Know an IP attorney for trademark registration and any infringement cases. Know a business lawyer for contracts, structure, and disputes. Know an accountant for tax, VAT, and financial compliance. And consider legal insurance, which gives you ongoing, low-cost access to advice. Hire a professional when contracts pass a significant value, when infringement is at commercial scale, or when a dispute crosses borders. Your final exercise is to map this network, now the offices, the accountants, the associations with estimated costs, and when to call each. Have the contacts before you need them urgently. Let's end with the mindset that makes all of this manageable. Compliance is a habit, not a one-time task. Regulations change constantly. The businesses that stay compliant aren't the ones that memorize every rule, they are the ones with good systems. So build 3 simple habits. First, Subscribe to updates. Follow your national IP office, your tax authority, and your industry associations. Second, diarize every deadline. A visible compliance calendar turns scary obligations into simple, ordinary reminders. Third, review quarterly. Once every 3 months, check what's changed and what's due next while it's still easy, not urgent. Here's the stakes and the reassurance. One regulatory change you miss can create months of disruption. But a small, regular habit prevents almost all of it. Compliance, like creativity, rewards showing up consistently. Let's bring Module 4 together in 3 ideas. Lesson 1, Intellectual Property. Recognize and protect what you own: copyright, trademarks, and patents, and be ready to defend it. Lesson 2, Contracts and Structures. 5 elements make a contract legal. Specificity protects you, and you choose the structure that fits you today. Lesson 3, Compliance and Risk. Manage the layers of law, meet your tax and GDPR obligations, and build your legal network before you ever need it. That completes Module 4. Your creative business now stands on solid legal ground. Protected work, strong contracts, the right structure, and compliance you can maintain. This project is funded by the European Union. Thank you for watching.